All right, so thank you all for coming in. The current voting deadline is tomorrow at 4 o'clock. So it looks like we are one step closer to getting this Odyssey completed. And what I wanted to start with was answering the questions that were sent in. So let me start with that, and we will go from there. All right. So number one is, do we get stock in the settlement? And the answer to that is no. Individuals are not going to receive stock. What will happen is that the formula for computing how much stock in PG&E that the trust is going to get, we've talked about it before, but it's basically 14.9 times the earnings, which the last time they were published, the estimated earnings in 2021 were a little over $2 billion. I think it was $2,020 million. So you take that amount and you multiply it by 14.9, then you multiply that by the percentage, which is 22.4, and that came out to 6.75 billion. So that's what happens. That amount of money is going to go into, that amount of stock is going to go into the trust, but no individual will be forced to take stock. And while we were checking to see if the trustee was going to allow individuals to have stock, they've decided no. What they're going to do is just sell the stock and then pay everyone in cash, and then people can obviously do whatever they want with their money. So that's the answer to that. There will not be any stock. Second question, and there were a couple of these. There have been a lot of postings on Facebook and some other social media about Michael Watts, Watts Guerra, and they've also tied me into them. So there's a couple of questions about Watts and Watts Guerra, so let me answer those. First of all, again, while we have worked together in this case in the sense that there have been a group of us, we're known as the Consenting Fire Claimant Professionals. Together, we represent about 70%, but we're not partners. We don't have a joint venture. We don't have clients in common. We're just a group of individuals who are working together to try and get the case done. That's the Consenting Fire Claimant Professionals, and that's the relationship that I have with Watts Guerra and Michael Watts in this case. Again, as I've said before, I think Michael has done an excellent job. I don't believe there's a conflict, and I don't believe that any of those complaints that have been put forth on social media about him having any kind of a conflict or him not acting in his client's best interest have any merit. But obviously that's up to the individuals, and that's between Michael and his clients. For our purpose, the way that we would work together is that because we had the two largest groups, we basically, once we got one other group in, we're in a position to block any proposals that we didn't like. And I think that was very effective because when, for example, some things came up that we did not believe would be in our client's best interests, then we could say, look, this is not something we're going to support. And so we were able to, I think, steer the negotiations in the right direction. So the question is, specifically, why is Singleton being accused of the same thing Watts is? And the specific questions are being in bed with PG&E, being paid by PG&E to force yes votes, and a couple other ones. Yeah, obviously, I have not been paid by PG&E. We get paid from a percentage, and obviously everyone knows this, of the amount that we recover for each individual. So the more we get for our clients, the more we recover. And the more money that we make. There's no side deal with PG&E. To the best of my knowledge, there's no side deal with Watts. I don't know how that would be a benefit. I mean, one of the things that I was speaking with a reporter this morning who was asking me about the allegations, and one of the things I said is that when you look at the amount of money that Michael Watts and his group are going to make if the deal goes through and works as planned, it doesn't seem to make any sense for them to try and sabotage it because there's a much smaller loan amount that some people that are tangentially involved in the case have made. So I don't, again, I don't think there's any validity to that. If anyone's interested, and all the documents are on our website, there is an opinion from an ethics expert. She is on the Ethics Commission for the California Bar. She was one of the drafters of the most recent rules. And she said, as someone who drafted these rules, I can tell you that the rule in question, which is Rule 1.7, does not apply here, and it was not broken here. So again, I think she's correct. And with all due respect to Mr. Abrams, who's not a lawyer, and the other lawyer who made the complaint, I think they're wrong, and I think the expert is correct. So in terms of being, of forcing yes votes, I do want to make this crystal clear. We absolutely do not want to force anyone to vote any way. We believe this plan is in not just your best interest, but the best interest of fire victims, which is why we're supporting it. However, you have the absolute right to vote no, and you also have the right to change your vote. If at any point you've heard something that makes you believe, look, regardless of what my attorney says, I don't want to vote in favor of this plan, I want to change my vote, you have until 4 o'clock tomorrow to do that. You can contact us. We will assist you in changing your vote. You could always vote no, even if you've already voted yes. Again, we've gone through why we think this is the best deal available, but if anyone disagrees, you have the absolute right to vote no. The next question is, why is the $19 million for administrative costs coming from the fire victim settlement? The reason for that is that from the outset, and this was the case in both the bondholder and the equity plan, and the equity plan is the one that we ended up going with, the administrative costs were going to be paid out of the fire victim trust. And the reason for that is that once the trust is funded, then PG&E will have no involvement in it whatsoever. And we felt that was very important, because what's happened in some prior cases is that, and by prior cases, I'm not talking about anything in this case, I mean in previous settlements where there have been mass torts and a defendant has paid a significant amount of money, but has been able to keep a hand in the process, so to speak, and to have any involvement, the defendant has a natural incentive to try and make the awards as low as possible, because if anything is left over, then they get to keep it. So the deal that we made was that we will pay all the administrative costs, but you do not have any involvement of any kind. And no matter what happens, even if there's money left over, and obviously no one expects there to be, but even if there is money left over, you don't get it. It would then go to the state of California or FEMA. They have the reservation there. But again, we felt it was very important not to have them involved. And because of that, the agreement we made is that the administrative costs will be paid from the fire victim settlement. Now, we believe that the majority of the administrative costs are going to be covered by either the interest on the money, the stock appreciation, or the third-party settlements. And this is something we've talked about before. But remember, we do have these claims, and they're being pursued right now by a group of attorneys that's been retained by the trustee. We do have these third-party claims against the tree trimmers and some of the other contractors. So people like Davey Tree, people like ACRT, Trees Inc. These are all contractors who were hired by PG&E to inspect the lines and to trim them and to make sure that the trees in a lot of these cases didn't get close enough. They failed to do so. And so what's going to happen is we're suing them. And after the attorneys who are doing that, we're not involved, but other attorneys have been hired. Once they are paid, then all of that money will go into the trust. And, you know, we've talked about this before. We think the total amount is going to be somewhere between 500 million and $1 billion. So we think that will be more than enough to both pay off the federal government, because as you recall, the federal government gets the first 117 million there, After that, we still believe there's going to be hundreds of millions of dollars left over, and that money would go into the trust. And the hope is that the entire 13.5 billion is going to be available to make payouts, and all of the administrative costs, everything else is going to be paid out of that. So that's the answer for the 19 million in costs. Next question, number 4. This is a very good one. Are attorney fees part of the settlement agreement? So the answer there is that the trustee has not yet decided if they are going to award attorney fees or not. And this is something that I've been pushing very hard on. I had 2 calls this week, one with the people at the trustees and the other with the group that they hired to come up with the model. That's Brown Greer, and we've talked about what they're doing. They're the ones that hired, it's about 200 people to run these models and to set them up. And so what I've explained is that for our clients, this is critical, because when you have these economic losses, you need to be able to recover the attorney fees on top of that in order to be made whole economically. And the law on this is crystal clear. It's Code of Civil Procedure section 1036, and it doesn't say may, it doesn't say can, it says shall. And shall, under California law, has a very specific meaning. It means that the court does not have discretion. So our view is it would be a violation for the trustee not to award these. That's the position that we're pushing. And right now what I'm doing is working with the other plaintiffs' attorneys, the same group of consenting fire claimant professionals that we got the deal with, to make sure that the trustee includes that in there. It is not in now. And so if anyone is concerned about that and wants to vote no because it's not in, I completely understand. We are going to keep pushing there. And I can't say I'm 100% sure, but I'm very optimistic that it is going to be included. I know that if it is not included, it will be over my strenuous objection. We, if necessary, will file an objection with the court to the plan and say, while we agree with the overall plan, this one element needs to be adjusted. We think this is critical, and we're going to keep working on it. The next issue was, this is another question about Michael Watts. Is it true that he does not have a license to practice law in California? The answer to that is yes. He is a Texas lawyer. The way that this works is that when you have a license in one state, you can appear what's called pro hoc vice in another state. And this was brought up on, I believe it was Tuesday at the hearing. Mr. Watts had a pro hoc vice in district court, but not in bankruptcy court. So that was remedied, and that has been resolved now. He now has a pro hoc vice in bankruptcy court as well. Okay, next questions have to do with a recent bankruptcy court hearing. The question is PG in breach of the agreement for not ensuring that the value of the stock will be 6.75 billion? The answer to that agreement is no. They are not in breach because the terms of the plan were very clear. They did not say 6.75 billion. They said that there would be this formula for calculating the stock. And this was something that was in the bondholder plan. So when we got PG&E to match the bondholder plan, that was how they did it. And they didn't, there was never an agreement in either the bondholder or the equity plan that it would be 6.75 guaranteed of stock. It was 6.75 based upon this formula, which is 14.9 times the estimated 2021 earnings. And then initially it was 20.9%, and then it was up to at minimum 22.4, at maximum 23.5. That amount will be determined as we go forward, but that was the anti-dilution provision that was put in. So the next question is PG&E's extra debt, and does it affect the stock value? And specifically, they're talking about an additional $3 billion in debt. The answer is yes, it could, and that is the reason for the anti-dilution provisions. Once PG&E did this, and the reason they did this is that the governor and the CPUC required that they spend certain amounts in order for them to comply with the CPUC's requirements, and for the CPUC to certify that the bankruptcy agreement satisfied AB 1054. So what happened was they had to raise additional money. We then went back to them and we had a mediation. I believe the date was March 9th. And at this mediation, we said, well, wait a minute, you've added more debt. That means we need more stock to protect our clients. So we went back and forth, and eventually we agreed that the amount of the stock would be increased from 20.9 to somewhere between 22.4 and 23.5. What will happen is once the stock is issued and we see the final numbers and what we're looking at, then we're going to have an additional negotiation to see if we can agree where between that 22.4 and 23.5 the final number will be. If we can't agree, then we've in advance agreed upon an individual who will arbitrate and decide the issue, and we were the ones that selected that individual, not PG&E. So all of us in the room on our side believe that he is going to be favorable to us if he has to make that decision. So the answer is yes, the additional debt does affect the stock value, or rather it could affect the stock value. I think it's likely to say that it will, but that's why we had the additional anti-dilution provisions that were negotiated in March. Final question is, did Judge Donato say that the stock was worth 4.75 billion, not 6.75 billion? No, he did not. What happened was, in advance of a prior hearing, and I believe the hearing was set to occur on April 7th, if I'm not mistaken, one of the groups that is opposed to the plan, a group of class action lawyers, hired an expert to say that as of that date, he believed the value of the stock was much lower than 6.5. I believe the exact number he used was around 4.85, although I could be mistaken. Now, there were a lot of problems with that assessment. First and foremost being that he did not use PG&E's projected earnings. He used projected earnings from Edison, which obviously is a different company. And he also was making this assessment right when the COVID-19 stock crisis was at its worst. So basically what he did is he went in, he used a different metric for evaluating it, not what the deal was, but something completely different. And he did it at the absolute worst time during the past, really 100 years to do that. So to their credit, the TCC, when they saw this, said, look, we don't agree with that. We don't think that the value is 4.85, and we don't think that the methodology you've used is correct. So that's where that number came from, but it was not something that Judge Donato or Judge Montali agreed with. It was a single declaration by someone who has not been involved in the case before or since. And again, it was based on metrics that are different than what we agreed to, and it was done at the worst possible time. So while we can't guarantee that the stock is going to be worth 6.75, I can say with great confidence that the declaration that was submitted and that this question is in regards to was not an accurate declaration. Okay, so that is basically the update on the questions. The only thing that's really happened in the last week of any significance was that we had a hearing on Tuesday. At that hearing, Will Abrams, who is a Tubbs Fire victim, asked Judge Montali to throw out approximately 13,000 votes that were cast by Watts Garrett clients. The argument that Mr. Watts and one other attorney who represents a Camp Fire victim made was that they believed there was a conflict of interest, and because this conflict of interest occurred, these 13,000 votes should be thrown out. Judge Montali took that under submission and has not ruled on it, but I don't think anyone thinks that is going to happen. Other than that, the voting is going to close tomorrow at 4 p.m. We have a general town hall. I don't think we're going to discuss anything that we haven't discussed here, but this is the one with the larger group of attorneys. So you've got the Watts-Guerra attorneys, you've got Robbins Cloud, you've got Bridgeford, Franz, McNicholas, a large number of attorneys. We all get together. We make it available to all our clients. So there could be as many as several thousand people on. And then anyone who has a question can ask any one of us. Again, I don't think there's going to be much to discuss there, but that will be tomorrow at 12. So anyone who wants to join is more than welcome. Chewy, why don't we open it up and let's take some questions.
Yeah, I have a submission here. It says, can you explain your relationship with the Royal Bank of Canada, if any?
Oh, yeah.
And Royal Bank of Canada's relationship with PG&E?
Certainly. That's a good question. So one of the things that happened during the argument on Tuesday is two things, really. The first was we explained, and this was part of the declaration from the expert, that many law firms use lines of credit to fund day-to-day operations. Every large firm that I'm aware of, your average corporate firms do it. Watts-Guerra does it. A lot of firms do it. We do not. We've been able, fortunately, to do what we call self-fund. So we use revenues from other cases to fund current ongoing cases like this one before they settle. But because I very much believe that you should always be prepared, and I'm a big believer in contingencies, we have a $5 million line of credit with a local bank. It's called City National Bank. It's local to Southern California, which was bought by the Royal Bank of Canada a number of years ago, I believe in 2016. And so it's a subsidiary of the Royal Bank of Canada. Now, we have not used that line of credit. We have it open, it's available to us, but we have not taken any money out of it. So currently, we do not have any loans outstanding with either City National or the Royal Bank of Canada. But I just used it as an example to say to the court, for example, my firm has a line of credit with the Royal Bank of Canada, and the Royal Bank of Canada is tangentially involved in this case in, I believe, two ways. One is they were part of the initial financing in 2019. In March of 2019, PG&E borrowed, I believe, around $5.5 billion to fund its daily operations for approximately a year. And the firms that were involved in that, there were, I think, the 6 largest banks in the country were involved. So that would be JP Morgan, Royal Bank of Canada, I think Citibank, US Bank, and I believe Wells Fargo. There may have been one other, maybe Bank of America. But in any case, the largest firms around were involved in loaning PG&E that money. In addition, Royal Bank of Canada was hired by the Tort Claims Committee, so the committee that is supposed to represent the interest of fire victims, to advise them in negotiating the underwriting agreement with PG&E for the stock. So to the best of my knowledge, that is what Royal Bank of Canada's involvement is. But one thing that I think is important to remember is in this day and age, particularly with a deal this large, my understanding is this is the 5th largest bankruptcy in history. It's over $59 billion. I believe there are 70 major financial institutions involved. It would be very hard to find anyone who's not in some way connected to some entity that has some interest in this case. So that was the point that I was making, but I can tell you that we have not borrowed any money from the Royal Bank of Canada. So obviously, even if they wanted to, they're not in any position to influence us in any way.
It says, you opined that it was unlikely that any money would be left over. Is it your projection that the total monies available will fall short of cumulative claims plus attorney and expert fees?
It's a good question. So the question is the 13.5 billion going to be enough? And that really is the key question. We certainly hope it will be. The models we ran indicated that it likely would be, but we cannot guarantee it. There is certainly a chance that we are going to be short. If that happens, then obviously it's going to impact everyone. One thing I want to make crystal clear is this is not a situation where attorneys get paid one set amount and then whatever clients get, they get. It does not work that way. We get paid a percentage of what you recover. So if you were only to recover 95% of what your award should be, it means that we're only getting 95% of our fee. It's not like we get our fee and then you get whatever's left over. I just want to make sure that everyone understands that. So again, we hope it will be, but we just can't say for sure.
We can open it up.
Okay, yeah, let's open it up.
Feel free to unmute yourself if you have a question.
All right. I feel like the teacher in Ferris Bueller's Day Off. Does everybody remember that movie? Bueller?
Jerry,
Somebody's got to have a question.
Jerry, I have a question for you.
Yes, sir.
Ultimately, you're talking about the attorney fees coming out of the $13.5 billion fund.
Yes,
what do you estimate the costs for all the fire consulting claimant professionals to be? Because obviously that dilutes the fund to the survivors.
Well, yes and no. I think in general, the attorney fees are a third. So when, and again, I know some are lower, some are higher, but most attorneys charge a third in these contingency cases. So what will happen is the funds will be paid out individually to an individual. And what we want is for the attorney fees to be added into that. So one of the ways of doing it is for the trustee to calculate the economic damages, the non-economic damages, and then make that the award. And we don't believe that's fair because the law specifically allows you to recover attorney fees for your economic damages. So we believe it should be economic damages, attorney fees, and then non-economic damages. You take that entire award, that goes to the plaintiff, and then our fee comes out of that. So, I think it'll be roughly a third is how much attorneys will receive, but that'll be, there are several hundred attorneys involved, and that's how that will work out.
Okay, thank you.
Sure.
I have a question. This is Sharon.
Yes, ma'am.
Could you give us an update on the voting so far?
Sure. For our clients, we have almost 4,000 who voted, so roughly 60%. It's been overwhelmingly in favor. It's over 98%. In talking with my fellow attorneys, some of my colleagues, most attorneys are in that range. Everybody that I spoke with is over 95%. There are a couple of attorney groups with small numbers of people who've recommended that their clients vote no. So I think obviously you'll see a much lower acceptance rate there. But my guess is when we do get the numbers, and that should be late next week after prime clerks had the chance to calculate everything, we're going to be looking at about a 90% acceptance rate.
Thank you.
Sure.
I don't have any more submissions.
No submissions?
So I have another question.
Please.
Excuse me, this is Sharon. I have another question.
Please.
So based on the assumption that this is going to be approved by all of the voters, what can we, or when can we anticipate then starting to look at our individual claims as far as finalizing them and getting them ready for submission?
That's a great question. So that's what we're working on now. We're going now under the assumption that this is going to be approved. And so one of the things that we're working on is to work with Brown Greer, and that's the company that was hired by the trustee and the claims administrator to help them come up with this process that we're going to do. So we have weekly calls on that, and we're putting that together. The goal is to have that finalized by July 1st. And then what we want to do is start getting as many as possible submitted. So if your case is ready to go on July 1st, and that is indeed the date that it opens, personally, I think that's probably a little optimistic. I think you're probably looking at mid-July, given what they have to do and create this from scratch. But let's say it's mid-July, July 15th. We would then start submitting them in July 15th. And the goal is for the claims administrator to be able to review a significant number of cases before the August 29th funding deadline, so that once that funds on August 29th, which is the current effective date, then they would be able to start making payments immediately. That's the goal. Obviously, in the real world, you always run into some kind of a snafu, but that's what we're trying to get done. And I'm optimistic that if we do get that funding on August 29th, which again is the current date, then we will be able to start making those payments in September.
So I think I did a poorly job of phrasing my question, because what I was referring to more was our working with members of your staff in preparation of finalizing our claims.
Okay, my apology. I misunderstood your question. Yes, that will happen very soon. So if you have not spoken with one of our team members to finalize your claim and you're ready to do that, no problem. Just let us know. You can call us. You can email us. Other than that, what we're doing is we're going through and we're looking at cases for which we have all the information we need. So that would be completed reports, personal property list, and then we're doing narratives for all those cases, so that once we're completed the narrative, we can go ahead and submit them. But again, you're welcome to do it at any time. Just let us know.
So then another question pops up. So if we want an opportunity to go over the final claim before it's submitted, we just send a text and one of your staff members will do that?
Sure. Yeah, you can absolutely go over it before it's submitted. It looks like the way that it's going to be done is going to be online. So, for example, here's, I've got one of my prior lists right here. The way that we have traditionally done it is that we've created one of these, and I probably can't see it, but let me block the name out. And what we would do is we would create a list like this, and it would be essentially a grid where we would go through all of the damages. We would then put on attorney fees, non-economic damages, and then have a narrative packet behind it. And that would be our submission. Here, what they're trying to do is to have everything go through the Brown Greer portal, which means that everything will be online. So to submit it, it won't be a packet like this that we can send you, but what we can do is go through all of the numbers and your narrative with you. Then we input the numbers and we put in the narrative and any supporting information. So we can absolutely do that with you before we submit it through the portal.
Great. Thank you very much.
I do have a submission here. It says, assuming the attorney's fees will be 4.5 billion, leaving 9 billion for fire victims, why does it matter if the fees are on top?
It's a good question. So here's why it matters. Here's why I believe it matters. First of all, it is the law. And I think that when we're doing this, we should do it as consistently as we can with what would happen in Superior Court. Because the goal here, at least from my view, is to put you in as close as possible a position as you would have been if this would not have been a bankruptcy and it would have been handled in Superior Court. In other words, you would have recovered your economic damages, your attorney fees, and then your non-economic damages. That's not going to be 100% possible because bankruptcy is a different process, but that's the goal. So the reason that I think the attorney fees are so important is because we want to make sure that people are made 100% whole economically. And the only way that can happen, or the only way we can guarantee that, is if people get their attorney fees on top of their economic damages. So the argument that I have been making is, look, if it is not possible to get everybody 100 cents on the dollar, then what we should do is calculate out what everyone's should be putting in the attorney fees and doing it the exact same way we would do it in Superior Court. And then if things have to be reduced by a certain amount, then that's what we do. But the reason that I view it as so critical, it doesn't ultimately affect the amount that we get, for example, but I think it's critical because it's a way of allocating the money so that the economic damages are fully paid. And I think, at least from my view and the people that I've talked to, that is everyone's main concern. They want to make sure that they have enough money to rebuild their house, they have enough money to replace what they lost. They would certainly like, on top of that, to get money for emotional distress. But if there's less money there, then it should go to making sure everyone receives 100 cents on the dollar for economic losses. And then if they get less for non-economic, then so be it.
I don't have any more submissions.
Okay. Do we have any more questions from, for lack of a better term, the board?
I have, yeah. Mickey, one sec.
Okay, we've got a question that's being sent in. Go ahead, Chief.
No, go ahead. Mickey, go ahead.
Just wanted to know which of your clients will be paid out first. Like if you do get funded in August, who gets paid in the correct order starting in September versus putting off till next year in 2021?
Sure. Good question. So what we traditionally do is we submit as a case is ready. So the people that get their stuff in first and are ready to go first will be submitted first. The one exception that we make is there's a very small group of people that in the law are known as preference plaintiffs. And that term preference comes from the fact that under a specific section of California law, section 36 of the Code of Civil Procedure, if you are 70 or older and you have a serious medical condition, it entitles you to a preference in trial setting and you essentially get to go first. So what we do is we take people that are elderly and in poor health, and usually, fortunately, that's a small percentage of the overall population that we represent, and we put them at the front because, obviously they are the most vulnerable. After that, we just do it on a first come, first served basis. So the sooner that you get us your documentation, we'll submit it, and then once it's ready, it will be paid out. Now, the one caveat there is this: as the claims administrator is deciding on these claims, the easier cases, I believe, are probably going to be paid out first because those are going to be ones where there is not as much of a dispute. When you get into more complicated cases, then it likely will have to go to mediation or arbitration. That will take more time, and so those will be paid out later, even if they were submitted earlier. But what I would encourage everyone to do is just to get your information in as quickly as you can. That way we can submit it sooner rather than later, and you'll get paid as quickly as possible. All right, do we have any additional questions? Okay, so what we're going to do is the voting will close tomorrow, but I'd like to have another one of these next Thursday, for anyone who's interested, just to give you an update on the voting and what's happening. And then the next major event in the case is going to be the 27th. That is going to be when the court holds a hearing to determine whether or not to approve the plan. That's obviously going to be after, not next week, but 2 weeks from now. So next week, we can have a hearing, talk about the results, not a hearing. We'll have a town hall. We'll talk about the results of the vote. I'll let you know what issues are going to be presented at the hearing on the 27th. And we'll have the hearing then, and then we'll have a town hall the following day, and I can let everyone know what happened at the hearing. Before we sign off, any last questions? Okay. All right. Well, thank you very much, everyone, and I'll see you next week. Take care.